the Chief Justice has been talking tough and revealing and sharing her vision for speedy justice, for trusted justice delivery with all of us. Within this very short time, she has managed to get as many as 12 different documents essential or guidelines essential to helping fast-track justice and in a manner that is that will be fair and efficient. We'll return to that shortly.
I deeply crave, along with all well wishers, I'm sure, to change the tag of corruption, ineptitude, and inefficiency around the neck of the judiciary and judicial service of Ghana. We cannot do this without the support and attention of all stakeholders. The Bangalore Principles of Judicial Conduct and the Latimer House Principles are international instruments that Ghana's judiciary are committed to. In order to shake off these tags, training needs to be supplemented with consistent culture-changing strategies to deepen ethical models of work in the courts. Judicial administration must close the gaps through which court users are subjected to exploitation and rent-seeking behavior. This demands the removal of as much of the human interfacing that court work is exposed to. Court officials are expected to work with independence, with impartiality, competence, and integrity. Much of these ethical values are lost in the heavy traffic of human interfacing between court officials and court users, including unknown brokers functioning around the courts. The vision for producing culture-changing reorientation programs cannot be achieved without the active participation, the active partnership and support of stakeholders, including communities of businesses and donors.
He addressed that, look, we hear you, that you are not happy or you don't understand the process by which we choose our panels. And here is the process, or here is what I'm going to do to make sure that people have confidence in the way the panels are structured. If you just come and give kumbaya speeches on there will be no corruption and so on, people will just listen and say, oh, we've heard all of this before. We want you to have key performance indicators, specific, measurable outcomes that 2 months from now or 3 months from now or 6 months from now that we can look at and then see whether or not the things that you are saying are really happening. For instance, I would have preferred for the Chief Justice to come out and say, look, from now on, we are going to set a standard time for filing an application and completing the case. So for all land cases, from the initial filing of the application to completion of the case, the time budget is 24 months. For a family law or divorce case, the time budget is 18 months, and so on and so forth. So for all the cases that we hear in this country, litigants have a fair idea of how long the case is going to be. Obviously, in some cases, we are going to exceed the budget. In some cases, we are going to fall under the budget. But at least there's a budget. And because of the budget, we are able to know when there are variances. And then we can try to investigate the variance to know why in specific cases there have been delays.
The leadership was encouraging you for this laudable initiative. May we remind ourselves that the greatest number of complaints about the justice delivery system in Ghana border on ineptitude of judges, attitude towards litigants, and lawyers, as well as delays with the conclusion of cases. I'm of the fervent belief that your vision will result in a reduction of this phenomenon. Ultimately, in my respectful view, there also needs to be a rethinking of the exercise of the jurisdiction of the Supreme Court to ensure that the workload of the Supreme Court is manageable and conducive to efficiency. Drawing on the practice and experience in other jurisdictions in and outside the common law world, the Supreme Court ought to be able to, by recourse to the enactment of regulations governing the multiplicity of jurisdictions conferred on it, and within the constraints of the Constitution, restrict the number of cases it has, especially on appeals from the Court of Appeal to the Supreme Court. This will result in the delivery of more quality justice by the highest court of the land. I say that a digitized environment results in transparency, accountability, and efficiency in the public sector, and ultimately helps to eliminate and prevent corruption. The prospect of improved productivity and reduction of costs that digitization brings requires that the judiciary embraces same fully. I have no doubt that we will achieve a fully digitized environment in the tenure of a leadership, the Chief Justice. Indeed, I see the era in which there will be the end. I see the era in which there will be the need for more virtual court houses, easily accessible to all from any part of the world, rather than physical court houses constructed in communities and accessible to only a few, much closer than anticipated.
Right, so you heard Chief Justice, Her Ladyship, Gertrude Torkornoo, and she is leading what she calls the leading justice. That's her vision, leading justice, where LEAD is an acronym for law, ethics, assets, due process, and digitalization. And she says that she received a visit from a cherished Ghanaian leader, Apostle Eric Nyameche, the chairman of the Church of Pentecost, who took her aside, and as Moses' father-in-law, Jethro, must have done when he saw Moses wearing himself out as a judge without the support of dependable partners in his leadership task. She says the esteemed apostle pointed out to me that in order to obtain extensive support beyond the cluster of help that the judiciary has used to working with, and the needed cooperation of the people of Ghana that I must serve, I should consider articulating the distinct goals within the vision shared on June 12, 2023, that's when she was sworn in, and share same with the nation with the objective of mobilizing support from as wide as a national and international base as can be obtained. And she was thankful for the apostle for that advice. And so it has led her to do the unusual. Roxanne.
Thank you. First of all, let me commend the CJ for this approach. But my difficulty is the personalization of the practice direction guidelines. Because you see, we are all trained. We know that practice directions are issued by the Supreme Court.
They have been issued by the CJ?
No. They are issued by the Supreme Court. We call the Supreme Court practice directions, not Chief Justice's practice directions. You can cross-check.
The practice directions after the Bafuboni case,
yes,
for disclosures, yes, in criminal trials,
yes,
were issued under the hand of the CJ.
They are issued in the name of the Supreme Court. Okay. So, but the attempt, because I'm saying, so are we going to cite it as CJ Torkornoo's practice directions?
No, the directions tell you how they should be cited, each one of them. If it has to be court-connected ADR, if it has to be pre-trial, yes, for commercial cases, yes, and all, it tells you how to cite them. And so, the individual's name doesn't, yes, come in.
Sure. Okay, so, well, then I'm guided.
Right.
Okay, so I'm happy about the practice direction because you see, it goes to fill the small lacunas that we have in our rules of court procedural laws and all that. Then they also have a force of law. You know what I mean? So these directions will help. But you see, I am hearing the CJ speak highfalutin sounding words in terms of policy approach and all. And I'm gauging that with a conduct. I went to court. I filed a matter and followed it up with an application for interlocutory injunction. The registrar of the courts, and I have another problem with that arrangement. How come we have a circuit court appointed as a registrar of the Supreme Court? How is that possible?
A circuit court judge?
Yes.
What's wrong with it?
There's everything wrong with that. Because how are you going to evaluate the work of the circuit court judge as a registrar? Because the work of a registrar...
The judicial secretary is a judge, is that not so?
She is.
Correct.
She is.
You haven't found anything wrong with that?
So I speak of approach. Because the judicial secretary, she has a constitutional role. If the judiciary decides that a trained judge should occupy that office, so be it. But the registrar of a court within the Courts Act doesn't function as a judge. So if you have a circuit court judge who is supposed to be delivering judgments at the circuit level, then she will be evaluated for purposes of elevation. Who has abandoned that?
Okay, so she doesn't leave the job as circuit court judge. So it's like acting...
Who is complaining? Who is complaining?
I am complaining.
No, but they are the ones who have employed... The judicial service has employed the circuit court judge.
No, something.
We understand why...
I think...
And if the person is capable of playing a dual role...
Is she playing a dual role? Is she sitting as a circuit judge and at the same time functioning as a registrar of the Supreme Court?
It could be secondment of sorts. The notion.
No, that is
to
not
be
the case.
registrar.
Look, if we speak of reforms, let's speak of reforms properly. And I have a problem that we have a judge who is acting as a registrar of a court. So I filed a process. You issue a notice to me that a date will be fixed 14 days after the respondents are served with the processes. Then the next day you decide to serve a process, not on me, not on my lawyer, or my lawyer's firm. The matter is determined based on that. Then a couple of days later, you come and tell me that we want to follow procedure, we want to... So I am gauging her words with her conduct. They are not in sync.
Well, there's actually, in the compendium, there's actually administrative guidelines on using the Supreme Court registry.
Certainly. It is coming after what I've suffered in the court. That's the point I'm making.
That you didn't know does not mean that this had not been in place.
How is that in place?
If it were not in place, a circuit court judge would not be acting as a registrar.
But I'm saying that which law supports that?
Which law does not support that?
You can't appoint a judge as a registrar of a court. That is my point.
Okay.
Because a judge is a juristic officer. Their duties under law is separate and their privileges.
Okay, so let's not reduce it to this. Let's look at the general...
It's a very material point that the privileges of a judge who sits over cases is different from the privileges and the conditions of service of a registrar of a court. And their functions are not coterminous at all. So that confusion must be cleared. 2, I am saying that these lofty ideas are good. She speaks of budget and all. But in streamlining the judiciary, I think that one of the tasks that is hurting the judiciary is not even about inefficiency. I haven't heard that our judges are inefficient. It is rather the workload. Having so much workload does not go to inefficiency. It's different. You can be efficient and delivering on your mandate with speed and all. But when the person who is assigning the cases is not taking into consideration the number of cases before you and keeps piling them, that cannot go to inefficiency. That cannot go to efficiency. So we should be talking about the fact that we've automated allocation of cases. At least in the High Court, in the Commercial Court, General Jurisdiction and all those divisions, I know that the assignment of cases are automated. Under the e-justice system, I don't know, certainly it's now digitalization, but the e-justice has been launched by government long ago under Professor Mills. In fact, when the modern court complex was built, that was when the e-justice system was launched. In fact, it had been launched much earlier, but it was piloted, but it was officially launched. So we ought to continue with that and streamline the assignment of cases to courts, that you don't overburden a judge who has so many cases or so many parties pending before him with new cases. That is why we are opening new high courts, new circuit courts, and all. That's why we are appointing new high court judges, appointing new circuit court judges, new magistrates. It is to offload the burden on the existing ones.
And also for places where there's no access.
Yes.
There are no courts.
Then
or the
I was
distance is
hoping
too-
that there would have been a report evaluating the impact of the e-justice program.
That's very important.
All right? So that we know that since the introduction of the e-justice system about 12 years ago, this has been the impact. And that when these policies are further introduced, it will help to improve the justice delivery system in A, B, C, D manner. We haven't seen that report. So when we have a court administrator for the modern...
Properly so called, the e-justice was not introduced 12 years ago.
When?
It wasn't. It's not 12 years ago.
When was it?
12 years ago, we were doing all the manual things.
No. It was piloted.
It was
We were in
piloted.
practice.
Where? Is it in the commercial court or the fast track high court?
It was piloted in the fast-track high court.
Right.
Then it was launched by Professor Mills when, in fact, I think he had then died.
But properly speaking, the e-justice is it's less than
more
5
about
years.
it's more
About 5 years or so old.
Maybe earlier.
No,
much
it's
earlier
not.
than that.
No, much earlier than that.
Oh, I
filing
attended
of
one of the training when we're all being trained as lawyers to know how to file your...
Including the bar took a bit of time.
Yeah.
The e-justice, when we practice filing of process,
Justice Wood,
and all.
I
Yes,
remember that.
yes, the CJ Wood, she launched it.
Okay.
Under a World Bank facility.
Then my memory is just...
Yes. No, you
not
are
helping
at the
me.
bar now.
Okay.
You recall
Yeah.
those days.
So she says she deeply craves, along with all their well wishes, to change the tag of corruption, ineptitude, and inefficiency around the judiciary and judicial service of Ghana. And she says they cannot do this without the support and attention of all stakeholders.
Yes.
A number of things are being put in place.
Yes, I agree.
Including the practice directions,
Yes.
guidance,
Yes.
about 12 different ones.
Yes.
We know that they may not be binding, but you can see they are made on the basis of law, judicial decisions, and they will help to fast track the court's process, correct?
In fact, if you read Shan and Shan in the UK Supreme Court recently, it has a force of law. But if you don't comply...
They do, right?
Yes. If you don't comply with the practice directions, a procedure pursued or a decision pursued can be struck down on grounds of
Because you didn't do your
non-compliance.
part.
Exactly.
Because the practice direction aligns with law anyway.
Exactly.
Right.
Exactly. In fact, it's like a subsidiary legislation. But these are judgment laws, so they call it judgment laws.
Right.
And they are force of law because they emanate from case law in terms of case management. These are all rooted in the doctrine of case management, which CJ correctly quoted. That is the Lancaster House principles and all. So I agree that we need to do this, but we are also gauging it with conduct. We also have a problem with empaneling the courts. Look, I have a matter before the Supreme Court, the First Lady's case. It's nearly 4 years, 2021 to now. The issue is about empaneling. One panel member is unwell, one is traveled. So now, on the 18th of March, I've been given another hearing notice to appear on the 24th. I pray that day, the judgment will be delivered. So if you have constitutional matters such as that deserves expeditious attention, and it delays this inordinately long, it's a problem.
All right.
Look at them.
So definitely you will be happy about the practice direction that is intended to ensure expeditious trials.
Of course.
Right.
Of course.
Dr. Kojo Asante, the chief critic, one of the chief critics, I should say the chief critic of our judiciary, particularly the Supreme Court, Professor Kwaku Azan, when he was called, I was surprised. He was full of praise for what was going on. The online publication of judgments, all of this are part of what is going to happen. He was very excited about it, and he said even the CJ should do more of what she has begun, and she doesn't have to be personally doing it. Officers can do that for her. Before this, she held a meeting where she took questions from journalists, and she says we owe accountability to the people, so we should do it. But he then says, what I want to see is a number of things. He has issues with automation of paneling. That should happen particularly in the Supreme Court, because Justice Atuguba, he says, had complained that for a long period he was frozen. He was not being empaneled for some alleged, disagreement with a chief justice.
At that time.
At the time. He says, if you set up cases, let's know that each case will take this period to be exhausted and so on. What do you say about that?
So, I mean, for me, there are three issues around the judiciary that I think we have to address. And this could not have come at a better time, because I really think that after Georgina Wood work, Sufia Kufu did a lot, but we need a new impetus, because if there was a time where we were really worried about the judicial, the trust and public confidence in the judiciary, it's now. And every indices that you can take is showing a certain trend. That is not good. In any democracy, the whole underpinning principle, transparency, all of those things, is basically to prevent conflict in society and to mitigate. And the rule of law is key to it. So I'm happy that we are having this conversation. The issue is one of the things that I think the judiciary needs to handle very carefully, because I think that, so we have an Article 2 problem, which already overburdens the court, and we haven't managed to resolve it. Because by Article 2, you just even cannot determine how many cases. But in other places, they will say we can only do 100 at a time this year, with some exceptions for emergency, maybe rights and other issues that are being violated. We need to look at that very carefully. But generally, because increasingly, and particularly around election matters, there's this discretion that the CJ has in empaneling. It has created a lot of perceptions around bias and independence of the court and so on and so forth. I think even sometimes there are cases that the Supreme Court should not be dealing with. These are political matters that probably need to stay in Parliament or other places. Because the more you take on these cases, anytime you make a decision, one person loses, one person.
But when they bring the cases, they must adjudicate. That's their job.
That's what I'm saying, that there are cases where the Supreme Court can say,
and decline jurisdiction.
Decline, not on the basis of law, not just on a whim, but on the basis of law. Because when you encourage, if politicians can resolve their matters, everything they are bringing it to your court, you turn the court into an extension of, and then your checks and balances become a problem.
That will not be their making.
Yeah, but it becomes...
That's what the courts are there for.
No, but what I'm saying is that we have to look at that system, both in terms of, and this is all by law, that's why I said, you have to look at the legal arrangements that you are making to limit and mitigate that problem. Because otherwise, if you look across West Africa, now every election, there is election adjudication. And it's rampant. So it's not even just the results that are being contested. In Nigeria, almost 11,000 or whatever cases that, some of them, they are still in the prelude to the actual election case. So I think that we need to look at that. We need to also look at as you're saying, time things. We have enough experience to know how much we're spending in terms of time on cases. For us to say, generally, it takes this amount of time. We can cut ABC, then as you said, we are already working on one particular aspect. So we need that budgeted time. And I think you can do that for land cases, because we have been doing it for a long time, we know. So that then you can deal with the exceptions. But it helps the public to know, if I engage a lawyer, this is really how much time, because it also deals with the access and the cost of justice. So there's a lot more detail that we need. Do we do a ballot system for the empaneling? How do you accommodate expertise? Because there are some judges who have certain expertise that you need for particular cases. There are many models around that we can adopt.
And they are shuffled so often. They may be very good in the commercial court. The next day they are thrown into a general jurisdiction court.
Criminal court. Taken from commercial court.
Exactly. And the point is that helpful to the delivery of justice? Is that helpful to the quality of the judgments that come out? Because I've read some high court judgments and I'm completely confused. So, there's a lot to be done around that. But I think for me, the trust and public confidence issue really also goes to the lower courts. And I think that's where sometimes we neglect. I spent about 6 months, some years ago, doing work on popular justice. Just anthropological, just going to the court, sitting there and observing. If you look at some of the things that goes on in the court, that is not law.
So she acknowledges that.
Yes.
She acknowledges
Exactly.
that and talks about the staff.
Yes.
They have about 7,000 or so staff, and there's a good number of these staff. They are not lawyers.
Yes.
They are just doing their work, and they need to know the law.
Exactly.
So that's part of the reason she calls this the leading justice. So in the lead justice, you have law. So they'll be trained on the law, so they'll know how to do.
And one of the things that I found useful those times was the disbursements of resources to these magistrates courts were linked to certain targets and obligations, which they reported, almost, you have to report on time. The registrar had this responsibility to report on time. And for me, it helps also in generating statistics. So there are so many, there's so many things you can use to incentivize a certain reporting and a certain alertness, to the processes that you've said, particularly the lower costs. Because sometimes when you get the perception surveys, it's really people's experiences at the lower courts that they are projecting. Because how many people come to the Supreme Court? How many people come to the Court of Appeal and other places? So those are the areas how the supervisory jurisdiction of the courts, particularly in the districts and other places. And lastly, for me, the judicial accountability component is also important. The idea of using contempt of court proceedings, I definitely don't accept judges using this to gag, speech and other things, because and we had a bitter experience with Dr. Ayini because organizations like us try to mediate
criticism and got into trouble
in this space, right? Where you have either the public is making commentary on something that they may not understand or don't have the knowledge about, and there is no way of sort of educating people. So organizations like us can provide platforms where you can bring academics, you can bring lawyers to try and control the conversation. And then when you do that, you get reported to the General Legal Counsel. So which lawyer can you bring to come and sit on the platform? So these things doesn't help, and we have to find a way.
Let me go to Kofi on that.
Those things as well.
Kofi, this kind of situations where, say, Professor Raymond Atuguba will do what he does as a survey, and he does what he believes is an academic work, subjects judgments to a certain analysis depending on who appointed the judge and so on and so forth, and how they made their decisions. And he is he is declared a persona non grata in the courts. Okay. Then you have, of course, Professor Kokwaza, and let's be frank about it. Professor Kokwaza, because he doesn't practice in our courts, he has all the liberty to say all the things he wants to say. There are lawyers who feel strongly about certain things, they will pass it through him, and you hear him advocate it very strongly. You cannot say some of the things that he says. Do you feel that now the Chief Justice is opening up in a way that will allow you to make your criticism without looking back and asking, if I go to court the next day, I will be welcome or not?
But I hope this is the start of the opening in terms of that. I am one of the people who believes that discussing extant cases, even on air, gives better elucidation and also even helps the judges. I'm one of those who believe that even if you are not, like you say, you can be fair without being, impartial. And I like it when
without being neutral, you mean, or
without
impartial?
being neutral. Sorry, the words
right.
I was looking for. I like it when I watch, for instance, Americans, discuss cases, and you have constitutional law Professor Tribe of Harvard University, retired constitutional lawyer, Justice Lutich, and very serious people discuss the case, and later you get a ruling. Let us be clear about this. The rulings of the courts, not just the Supreme Court, courts, can be discussed after the fact. The rulings of the judges can be criticized. And it is absolutely necessary for academics to be able to look at those rulings and do what Professor Atuguba did to them. Even suggest that how people are appointed as a terror has some effect. Their leanings, their previous, inclinations, and all kinds of things.
That's what you were taught in law school as American jurisprudence, right?
Yes. No, I'm coming.
I'm saying that thing you were talking about, what Professor Atuguba did. Okay. Go ahead.
Yeah. We will get to the point when we are sufficiently matured, where those things will actually be welcome. Right now, I think people are a bit too sensitive, and that is why we are going the way we are going. But let us be clear. What Professor Atuguba did is right. More of that ought to be done. Before the time runs out, let me make this case clear. I hear my brother, Dafia Meko, but please, let's be clear about this issue about the judge being a registrar. The judge is qualified to be a registrar, and nothing stops the Supreme Court from doing that. Indeed, like you said, there's another registrar who is a judge. That is number one. Number two, if the person is a judge and is a registrar, the question is whether their job as a judge is suffering or not, period. If they are performing their job as a judge well, and they are also acting as a registrar, I personally think it's a better thing than otherwise. Listen, what registrars do, even though they are not judges, has very serious judicial effects. That is procedural justice also. So for me, I was happy when that particular judge was made a registrar. The only issue is that she should not make her work as a circuit court judge suffer. Indeed, I am before her on a number of cases, and I can tell you she's a very good judge. And so far, I can't complain about her work as a circuit court judge. So let's be clear. There is no impediment in making a judge a registrar. Indeed, it is advisable.
Okay.
Provided her work as a judge.
Do you think, as some,
and I agree with the partner that.
Do you think, as some suggest, that your CDD Afrobarometer 2020 had a revelation that you should not be saying what she is doing is rare, but it has become necessary? Because the Afrobarometer, Ghanaians demonstrated lack of trust in most of the state institutions, including the presidency and the rest of them. The judiciary, 85% of Ghanaians perceived judges and magistrates as corrupt.
And I have said over and over and over again that much as perception is relevant, that particular perception, I believe, is not well informed. If you look at the volume of cases that go into our courts, and the fact that 90% plus, I believe, does not come up to any serious scrutiny. People go to court, they suffer one or two problems. I mean, I don't have time to give you examples, but I mean, they say all kinds of things. You've paid the judges. I think that perception is misinformed. But that is why I believe what the Chief Justice is doing is good. Demystifying justice delivery is always good. There is too much mystery around it. So the transparency in empaneling will be useful. And I agree also, the Supreme Court is a bit too overburdened, lightening their load issue. They can issue rulings without hearing and not breach any rule. I've argued that point somewhere, that you file your processes, they can look at it, let them, write it out and let you come for it without hearing you. Now, the problems come from the lower courts. That's where the majority of the issues are.
Yes,
so
Kofi,
again,
Kofi, as a practitioner, I will not hesitate in sharing your view that it is a small number that may be the ones giving the judiciary a bad name. But does it not matter? Just as we have discussed the scholarship secretariat, the outliers matter, don't they? Take the Supreme Court for example. When the political issues come up, public interest issues come up, the question that the judiciary and lawyers often ask is, what is the percentage of the so-called political cases that, you tend to use as the measure, or to measure whether the Supreme Court deserves the offensive, unanimous, FC tag, etc. But we forget that that is exactly what needs addressing. The one small bad nut spoils the entire, handful of nuts that you put in your mouth. Is that not it?
It is, and that's where I was going. Where I was going was that the problems come from the lower courts. And the problems arise out of a lack of transparency on how the lower courts operate, and the fact that the workload is such that sometimes the judges themselves, skim over so many things. So I was going to say, we should put more resources at the lower courts in terms of more justices, and I agree with more ADR and co. When we create that heavy duty capability at the lower courts, I believe these things will go down, especially if there's more transparency also in terms of the justice administration. All right. So I agree with what the Chief Justice is doing. What I want is for it to trickle down quickly, okay, so that there will be more capability at the lower courts, more transparency at the lower court. I mean, I have been able to go to court, and the judge has heard me and vacated her ruling.
Right.
All right. Now, somebody would think it's influence. It's not influence. When you make good, arguments, it's possible.
Yeah, we have all encountered those in the courts before.
So, when people talk about judges are human.
All right. So she says that she is going to invest in technology to enhance the efficiency of court processes and administration. She intends to expand electronically access library services with support from technology and innovation teams. If you go to the Supreme Court area, I think these days they've been trying to cut some of the records away. You will see them sitting there, the whole place. We don't know how to archive them properly. She says she intends to train faculty members for online training delivery to enhance learning accessibility, establish a modern archive center for storing and digitizing court records to ensure easy retrievals. She aims for a paperless court registries to facilitate e-justice initiatives and virtual trials. Well, what I don't like about virtual trials is that I was out of the country during the vacation, and because I am not in the jurisdiction, I can't join the virtual court. The virtual court is that you must be in Ghana still. So I traveled, but I wanted to deal with the case from wherever I was, and I was not allowed. Establish centrally managed transcription rooms for early processing of court proceedings to improve efficiency and cost. Develop manuals to increase transparency and due process in court proceedings. Well, that's 12 of them have been done so far. Provide paralegal learning materials for judicial staff and professionals to enhance understanding of legal processes. Offer online training programs with structured pre-delivered materials and post-trained exercises to ensure effective learning, among others. Haruna is still with us. Give us a minute of your appreciation of this, and then we'll move on to the next issue. Yes, Kofi?
All these things are good, but please, she should only focus on a few and do them well. One crucial one will be transcription in court transcription. That alone, if she achieves that, so that we stop having to speak at the pace of people who are typing, that thing does violence to your...
You know, the court complex system was actually built for an automatic transcription.
Yes.
Because I can, as we are talking here, I can use my phone and automatically record and transcribe what I'm saying. Why can't my court not do so?
So I'm saying here, please, Chief Justice, focus just on that. You will do massive, good to the whole system if that alone stops, and then we can do it with the rest too.
All right. Deputy General Secretary of the NPP, what will you say briefly about this?
Okay, Samson, thank you very much. First, I would have to commend the Chief Justice for this particular great initiative to ensure that trust is built within the justice system. Though I'm not a lawyer, I have seen that the content and discussion around this particular matter would have been very perfect if I was a lawyer. However, justice is something that is going to strengthen the democratic process in Ghana, and all manner of processes in terms of digitalization and all the processes that the Chief Justice has to install within the justice system to ensure that there is trust, there is just, and there is fairness in terms of delivery of justice. I believe that I am completely in support of such processes.
Great. And she started piloting the shift system also. I believe in those who say there should be rules of court or small legislation, like Professor Azan is saying, that gives timelines to everything. We did the Supreme Court presidential election petition where the rule said the trial should be expeditious. It took us 8 long months to do that, expeditious. In Kenya, they do it for 14 days. And we changed the law and we put a regimented schedule. That said 42, 45 days. And we did it under a similar thing. That will also help. Thank you very much. We'll go to the next issue. Yes, Roxanne?
Yes, 2 quick points. My brother misunderstood me. My point is that where you have a circuit court judge who is supposed to preside at a court mandatorily from 8:30 in the morning to 2 p.m., Monday to Friday, and at the same time serving as a registrar of the Supreme Court, there's no way that her work as a judge will not be affected. That is the point I'm making.
But so I'm saying there will be staff she can deputize.
No, at all. Okay. So she's not being evaluated as a judge, but as a registrar. And she's not.
So let's get to learn from the judiciary how she's evaluated before we are conclusive that she's not evaluated as.
In evaluating a circuit court judge for purposes of promotion to the High Court, they write exams, they attend interview, you submit report on cases you have done.
All right.
How is she able to do that?
Okay.
So I'm saying that approach, that arrangement is wrong.
All right. Thank you very much. Now,